Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm Rich Lenkov, the founder and CEO of SERMA, and also frequently the host of the SERMAPod, although we always like other people guest hosting. So if you're interested in guest hosting, let us know. We'd love to have you do that. And today we are fulfilling our mission of bringing you the most updated case law, updated developments in sports and entertainment risk. Really excited to have these guests today discussing a really important case. Teddy and Mark, welcome. Teddy, you are a relatively new SERMA member. Mark, you are hopefully going to be a SERMA member soon. I'll let you both introduce yourself and tell us why you're here. Teddy, why don't you start?
Absolutely. Teddy Brown, as Rich said, a relatively new SERMA member, but glad to be part of the organization. I'm the managing director of forensic accounting and damages at iDiscovery Solutions, IDS Inc. A lot of my work is related to contract disputes, intellectual property theft, and breach of contract, employee theft, and it circles around commercial and corporate industries, but as well as the sports landscape and some professional liability between agents and their clients as well.
Great. And Mark?
Hi, my name is Mark Clews. I'm a digital forensics expert and e-discovery expert at IDS. I've been working in the litigation support industry for over 25 years. I specialize in assisting clients and their counsel with complex data challenges. So any kind of preservation, interrogation issues, that's where is my sweet spot.
Awesome. Well, thanks again. So let's jump into the TaylorMade versus Callaway situation, because these are two of the most, possibly the two largest golf equipment manufacturers in the world, right? What's the conflict here? And let's start there. Tell us about the case.
Absolutely. So certainly by volume and total product, they're two of the top 3 or 4 in the world, if not the top 2. But when you think of golf balls, many times people think of maybe another brand and their premier golf ball. But TaylorMade and Callaway both make tour grade golf balls in which tour players and pro shops and stores stock in their stores. And there has been an accusation and ultimately a claim filed by TaylorMade against Callaway, stating that through digital marketing, through influencers, and through tactics of the sales individuals of Callaway, that there have been some slander, some false advertising, and statements made by Callaway representatives that are disingenuous towards TaylorMade and their product. I won't take this time to say that neither Mark nor I are working on this case or have any specific inside knowledge of any of the facts of this case, just what we've been able to collect from public filings, from reading the complaints, from news articles. But we will do our best to attempt to say if we were working on this case where we think our heads would go.
And this is, Mark, thanks, Teddy, for that. Mark, this is a lawsuit in federal court in California, right? It was filed in January of this year, 2026. And the allegations were false advertising, unfair competition, trade libel, related specifically to the Callaway Chrome Tour golf balls, right? I mean, for those of us, I'm not a golfer. We do a lot of golf content in SERMA. We actually have a great golf event coming up at Top Golf in Dallas in next week. But for those of us that aren't golfers, why are these balls so important that they're the subject of a lawsuit?
Yeah, I mean, it's certainly the performance of the golf balls is critical for people that are really interested in golf. And the fact that they claimed it as a mud ball is pretty significant because if you're involved in the golf industry and you play golf a lot, it's quite a derogatory term, which means the ball won't have the correct ball flight. So
mud ball, you said, right?
That's correct.
And that means a ball that doesn't have great trajectory, flight, strength, all that kind of stuff, right?
Correct.
Yeah. All right. Go ahead, Teddy.
I was saying the accusations are, these balls are claimed to be mud balls not because they are dirty or allegedly perform any differently, but under certain conditions, in this case, a UV light test, that the exterior coating of the golf balls show different colorations and have different brightness of UV coloring within the coating, that the the reps, the sales reps at Callaway are claiming make these balls mud balls.
Okay. And this is basically a false advertising claim, right? I mean, can you explain? I know you're not a lawyer, but I mean, can you explain basically what that means? Like, what are they alleging? I mean, false advertising sounds like something we all understand, but what's core to the allegation here?
So the allegation is that sales representatives, influencers, other social media members, as well as the those individuals who sell the product to professionals, pro shops, but also tour professionals, are using this claim and this demonstration to say that you do not want to buy these golf balls that are produced that are mud balls. You do not want to store these in, have these in your shop, have these in your PJ Tour Superstores of the world, have these in your Dick's Sporting Goods. That they are bad performing golf balls, and you will have dissatisfied clients and customers.
Okay. So, Mark, I know that and by the way, you've got a great article on this. We partnered with you, so it's available on our website. It's also available on the iDiscovery Solutions site, idsinc.com, specifically dealing with how forensic accounting and digital evidence shape these kind of cases. Let's jump into that. So what are we talking about there, Mark?
Sure. One thing that jumped to mind when I read the complaint was if you compare to like a traditional case where you're working with a business and their employees, it's very easy to identify those custodians that are in scope for this matter. It's very easy to sit down with IT, understand the different softwares and hardwares that are involved, and it's very easy to put those people on legal hold. With this complaint, it's outside of the company's network perimeter, a lot of these people, because you're going to have internal employees, but you're also going to have brand ambassadors that are under contract with these golf manufacturers. And then you're also going to have independent influencers who have like a paid agreement for a one-off sponsor. And then you're also going to have organic third-party creators that are seeing these posts, reposting them. So actually identifying the corpus of people that are involved is going to be a bit of a challenge in the beginning. And obviously, especially where there's the data is under third party, it's in this fragmented, largely public ecosystem with different platforms, whether it be a YouTube video or an Instagram post. We have to really strategize to different methodologies to get all these data once we identify it in a defensible manner. So certainly identifying the people that are involved and also understanding that they're going to have to be collaborative, because a lot of the times we're able to get the publicly available information, but if there's any kind of private information, direct messages, etc., we're going to have compliance from these third parties.
All right. So the question, that's all great. So Teddy, the question in these kind of cases and false advertising cases, typically when you look at damages, it looks at things like what profits were lost, right, because of the alleged conduct. Did the market share shift? What will it cost, very importantly, to correct the false advertising or the misrepresentation in the marketplace? How does forensic accounting play into that? I mean, what would be done if they hired a forensic accountant in this case? What would they be doing?
It certainly depends, I think, which side of the V you're on. So if you're on the, if you're on the side of trying to prosecute or the plaintiff side of the false advertising claim, you are asking for the infringing party to try to preserve the world. So you want them to try to preserve all internal data, all third-party data, all influencer data. But in reality, there is a internal discussion that has to occur as to where is the best. Sometimes say the term ROI, but where is the real place that you're going to get the most impact out of your claims, and where the best damages and least speculative damages occur. So if you're talking about influencer data, third-party data, brand ambassador data, you're now talking about Instagram, YouTube, TikTok, views, who's viewed it, what are market habits, what are purchasing habits by an end user. That becomes a very disaggregate data source, and it becomes a difficult quantification because you don't know how these people are interacting with the product, how these people are purchasing the product or not purchasing the product, and what their sentiment is. If you, from the the infringed party's claim, if you are taking a false advertising claim and saying we can focus this on the company's actions, the internal sales individuals, the wholesale accounts, so we know they are doing these demonstrations for the big box retailers of the world, and that caused them to change the purchasing habits of our product for this product cycle, or that caused them to not promote our product to their customers, and our sales were diminished. That is where really the false advertising seeps in to cause a financial damage um, in this case, TaylorMade with their golf balls being claimed to be mud balls, because now the retailers who are the customers of the manufacturer are changing the purchasing habits, directly affecting the top line and bottom line for TaylorMade.
So let's unpack that a little bit, because I want to, and your article does a great job explaining this, but a lot of our listeners, are not familiar with this. So you talk about in your article 3 different steps to, forensic accounting in this kind of case. First of it, and this is not that different, by the way, from, dealing with regular evidence, right? First, you talk about preservation, then you talk about collection, then you talk about analysis. Kind of walk us through the challenges in this kind of case when it's so widely disseminated. And then the follow-up, maybe to Mark or whoever wants to start, is how does AI make this even more challenging, right? Because you're talking about, unnamed sources, unreliable sources for collecting a lot of this. So walk us through those 3 steps and then talk about AI.
Mark,
Sure,
why
I
don't you
can
start
do
with
that.
the collection
Yeah, of
aspect?
course. Yeah, I mean, obviously the identification is the big issue initially, and then obviously preservation has to be very, very quick, because as opposed to a traditional approach, we can't put these third parties on legal hold. And so we need to preserve any of the publicly available information quickly. In this case, there was a video that was taken down, that was posted and taken down. And so once that's gone, it's very difficult to preserve. Fortunately, in this instance, or unfortunately, depending on what side you are, people were able to take screenshots and video that when it was posted. But that takes me on to the second question, the second point, which is authentication. Because of AI, because it's so easy to manipulate media now, pictures and videos, the process of preserving it has to be very comprehensive. There's got to be full chain of custody. There's got to be the person that are doing it is experienced and is able to attest to the approach they took. And obviously, not only preserving the video, but obviously preserving a lot of the metadata around it, and identifying, whether you need to preserve likes, comments, etc., where it was shared, who it was shared by. So, forensics tools allow us to do that, preserve it in a defensible manner that we're able to testify later to in court.
And I think on top of that, the real challenge comes in with AI and making sure you preserve that backend data. And Mark can touch on there are indicators within the backend metadata that could indicate a manufactured video or image as opposed to an actual user created image or video. But if we at IDS put out a video under Rich Lenkov promoting how great we are at IDS, but someone inside our walls made it, but put it out with your name, image, and likeness, to steal a term from the sports world. You may not even know it exists, but you are now a party to it. Or maybe we created a fake person, Rich Smith Lenkov, and we are creating personas that don't exist, but the breadcrumbs would maybe lead back to the original company or employee at the company. And that's where preserving the right data can help identify those breadcrumbs.
Correct.
Yeah, go ahead, Mark.
Just add to that. Yeah, there are files as AI is getting better and better. I know traditionally you used to be able to say, "Oh, look at the hands and there's certain telling parts of it that indicate that it's been AI created." But as it's getting a lot better, it's increasingly more difficult to identify. But there are breadcrumbs within the files themselves. A lot of these AI tools will leave their encoding software that was used in there. There might be dates, irregularities in there. Typically if it was a legitimate video, we would see the type, the make and model of the device that took the video, potentially GPS information, other type of information in there that's able for us to identify where it was originally created. Once it goes through a process of AI, some of that is scrubbed away. Some of that, it does leave some identification crumbs that can suggest that it was faked.
So this story is important, not just for the substance, but also as it relates to, other areas in sports and entertainment. Why do you think this kind of overlaps into other sports industry disputes over things like, brand valuation, sponsorship, endorsements, things like that? What lessons can we take from this to those other areas?
Well, certainly for me, from the financial side and values of companies and the risk to companies, to other sports companies, is really understanding who you're contracting with, understanding what platforms they're using and how they're using them, because you can contract with whatever influencer, whatever TikToker, and you think it is just hey, we're going to pay this person per click, per like, or a stipend per month to promote our product. But if they are putting out content that is contradictory to your brand image, contradictory to your brand values, there is a significant risk of detrimental valuation or potential litigation to your organization, by losing that control of what is being put out there, you know, into the social media space, on your behalf without your knowledge.
Yeah, and just to add to that, I would say that, I don't think it matters that this is, in the golf industry. It doesn't matter what industry, any industry that is using, influencers and third parties to further their brand is certainly going to face these challenges, because false advertising, certainly in this digital age, is like a living distributed campaign, and it's across platforms you don't control, through people that are unlikely to be employees. So it comes with unique challenges.
Teddy Brown and Mark Clews from iDiscovery Solutions, thank you so much for joining us on this episode of the SERMAPod. You can find Teddy and Mark at idsinc.com, and we hope you join us for another episode.